Nevertheless, this problem isn't necessarily the end of the story. For example, not all parts of the new range of mulch products may have been disclosed. We see from the case study that there could be numerous different product lines for land care systems, for horticulture, for landscaping, and land management use. These all might be different compositions, for example, and not all of them might have been on the original sales program. So some might still be novel and inventive and thus separately protectable. Furthermore, details of the process of manufacturing the mulch has not yet been disclosed. Likewise, the machinery involved in the manufacture is probably still secret. Bear in mind here that RSK had to redesign aspects of the machine. I'm quoting here from the case study. They had to redesign aspects of the machinery to produce product in sufficient quantities for the initial sales program. So there's still potential scope for patent protection on all of those details. All of this could be critical for the future, as the patents can greatly influence the value of the company, and there is an intention at some point to sell. This will therefore also provide the basis for future licensing, as there's an intention to license other manufacturers. All of this, I suspect, will be covered in greater detail in the licensing and M&A parts of the conference.
Robert said there's absolute novelty in most countries. So if you've disclosed the invention, you can't then apply. In the United States, what there is there's a 1-year grace period, which there has been since 1837. And the notion behind it is that you ought to be able to test, before going to the trouble getting a patent, you should be able to test it to see if it's good commercially, and maybe you refine it to make it as good as it can be. And so that's there. That was in the law starting, as I said, in 1837. It is still in the US law. There are an issue that comes up, which is the same issue Robert talked about, is the question of when does the clock start on all this? Because it could be that, like he said, that they've been in the business for several years, but maybe what you want to patent is something that somebody came up with only in the last couple of months. So you'd be okay there. So that's an issue. It's spawned all sorts of litigation because everybody fights about when the clock starts.
Trademark registrations really are to protect marks which serve as badges of origin. So if we think specifically about the case study situation, we know the company is already trading. Presumably it's trading under the name RSK. We don't know whether they've already filed for trademark registration at the EU and whether they did that before or after Brexit. And that's something I'm going to talk about a little bit. So if they had filed an EU trademark registration before the end of the Brexit transition period, if that registration had been granted before the end of the Brexit transition period, then on the 1st of January of this year, the UK office would have created a corresponding right to cover the UK from now forwards. If the application at the EU was still pending at the end of the Brexit transition period, then in contrast, Rachel and Stein would now have 9 months, so up to the 1st of September, to file a corresponding application at the UK office, which would give them an equivalent right to the EU application.